Stand up for me. Yes, ma'am. Ryan's not sitting. All right, so here's what's gonna happen. You're gonna go to jail today for a first-degree felony. My investigation shown that you wrote over $710,000 in checks to yourself and then deposited into your personal Wells Fargo account. I know you admitted to them that you did it and it was to help your mother.
I have an attorney and he did advise me not to speak to him.
Okay, so that would be a no.
232 forged checks, $700,000 stolen over 6 years. The accountant who took them now sits across from the detective who built the case against her. Will she say the words that end this interview before it begins? The legal architecture rests on 4 Supreme Court decisions and 1 Florida statute.
Is cuffs uncomfortable?
Mm-hmm.
Stand up for me. Yes, ma'am. Ryan's not sitting. Crimes unit. It's Emily Clement.
Hi.
It's my partner. So obviously we're here right now. Probably wondering how we got here. Why we're here. I've been investigating your former employer, Inspecs, and what's going on there. But obviously, you know what happened, and I know what happened, but I want to ask you some specific questions about the case and you know, about what your time there and stuff like that and what happened. Before I do so, I just want to confirm some basic information from that Miranda address. That's your current home, you don't know? First name Monika. You have a middle initial?
No.
Okay. And how do you pronounce your last name?
Hladik.
Hladik?
Mm-hmm.
And your date of birth?
02-08-83.
What's a good contact number for you?
802
802.
233
Mm-hmm.
5595.
Okay. That's the cell?
Yes.
Where's that area code at?
Vermont.
You from there?
Mm-hmm.
How long you been living down here?
14 years.
Oh, wow.
It's 15 years, 2009.
Okay. You go to college?
Mm-hmm.
Where at?
Champlain College in
Illinois?
Burlington.
Oh, okay. Vermont.
Yeah.
What'd you study?
Accounting.
Did you graduate?
Yes.
Bachelor's?
It's like a certificate of accounting. Basically, you do the bachelor's without all the extra stuff.
Yeah.
It's a cash price. Yeah.
Classes. Gotcha. Any kids?
No.
Any family in the area?
No.
No.
I have a boyfriend,
Okay. What's his name?
Mark Alexander.
How long you guys been together?
2 years.
You got?
He's a great guy.
Right.
I know. This is good.
Alright. Where are you working now?
I work for myself. I'm a real estate investor. I help people in pre-foreclosure.
What do you do for me exactly?
Help them through the process of either talking to their lender, trying to get a loan modification or whatever. There's just a lot of people in need right now.
So you must stay busy right now.
Yeah.
With the economy the way it is.
Yeah.
Yeah, it's a lot of people hurting. And how long you been doing that?
Year.
Since you left
Yeah.
Inspecs?
Yeah. A little more. Yeah. For a little while, I didn't know what I was doing.
Yeah. Well, I want to hear your side of things regarding that. Before I do so, obviously you were put in handcuffs, you're in a police station. So I'm sure you see cops and people read their rights and stuff like that. So I want to read your rights. That way you're informed of your rights and you know what your rights are.
Okay.
Because this is a standard form that you read everybody's Miranda rights. So I'm going to read it to you. I'll circle your response, and then after we're done, I'll have you initial, and then print and sign here.
Okay,
All right. Do you understand you have the right to remain silent?
yes,
Okay. Do you understand that anything you say can and will be used against you in a court of law?
yes,
Do you understand that you have the right to speak to a lawyer and have him or her present while you're being questioned?
yes,
Do you understand that if you got afford to hire a lawyer, be appointed to represent you in question if you wish?
yes,
Okay. Do you understand that you can decide at any time to exercise these rights and not answer any questions or make any statements?
yes,
Do you understand each of these rights I've just explained, Monika? Yeah. All right, having these rights in mind, do you wish to speak to me now? I'm going to ask you some questions about your time at Inspecs.
I have an attorney and he did advise me not to speak to him.
Okay. So that would be a no. Who's your attorney?
I don't remember his name.
Okay.
Yeah, I spoke to him right after it all happened.
Okay. Is he a civil attorney or a criminal attorney?
He's a criminal attorney.
Criminal attorney.
Yeah.
Okay. You don't know his name?
I'm not off the top of my head.
Okay.
I'm drawing a complete blank right now.
Okay. All right. So here's what's going to happen. You're going to go to jail today for a first-degree felony, scheme to defraud. My investigation shown that you wrote over $710,000 in checks to yourself and then deposited them into your personal Wells Fargo account. That's what I wanted to talk to you about today. I have all your bank records. I have the records from Inspecs. I know you admitted to them that you did it and it was to help your mother. So that's where we're at. But you've declined to talk to me. You said you have counsel, so we're not going to go any further with speaking. But
I'm sorry, no, that's
that's your right. But not special you to do that. So
do I need to find that at all?
no, not if you're not going to speak. So.
The framework begins with Miranda versus Arizona, decided in 1966. Miranda requires 4 warnings before any custodial interrogation: the right to silence, the consequences of speaking, the right to counsel, and the right to appointed counsel if indigent. The detective delivered all 4 verbatim, with individual confirmation after each. The subject's response triggers Edwards versus Arizona, decided in 1981. Under Edwards, once a suspect invokes counsel, interrogation must cease and may not resume unless counsel is present or the suspect reinitiates. The invocation must satisfy the clarity standards set in Davis versus United States, decided in 1994. Equivocal language such as, "maybe I should have a lawyer," has been held insufficient. The declarative statement here meets the Davis standard without ambiguity. What follows raises a harder question. Rather than ending the interview, the detective recites the evidence: bank records, accounting manipulation, the prior employer admission. Under Rhode Island versus Innis, decided in 1980, interrogation extends beyond direct questioning to include any words or actions reasonably likely to elicit an incriminating response. Whether this monologue crosses that line is contested, the state frames it as administrative disclosure with an explicit no-pressure disclaimer. The defense would frame it as the indirect compulsion Innis was meant to prohibit. Because no response was elicited, the question carries no consequence here.
So that's where we're at. What's going to happen now is I'm going to have a prisoner transport van. They'll transport you to the jail, come pick you up, and then, have you ever been arrested?
No.
Okay.
Patrol 2. Patrol
That is
4.
a high dollar amount. It is a first degree felony, so it doesn't get any higher than that as far as the felonies go, and that is based upon the dollar amount. So I don't know what your bond would be if you are assessed a bond.
Okay.
Do you know how that works at all?
No.
So essentially, you get arrested, you can either be released on your own recognizance, which means they just let you go on the promise that you'll return, which I highly doubt would happen in this case because of the dollar amount.
Okay.
The
I
other-
don't have that.
Yeah, the other option is they would issue a bond. And they may say it'd be a $10,000 bond, it could be a $30,000 bond. That means you would need to contact a bondsman, and they usually ask for 10%, so you have to pony up like $300. But that's just an arbitrary number. Again, this is a high dollar amount, so it could be substantially more than that. I have no idea, but that's what's going to happen now. So let me get the transport van going.
Am I able to make a phone call at all?
Oh, thank you.
You'll be able to make a phone call when you get to the jail. Do you have your cell phone on you?
No.
Okay. Do you know any numbers?
I think so. I've been trying to remember it the whole drive here.
Okay. Do you have a house phone?
No, it's my boyfriend's
Is
cell
Mark
phone.
at your house?
No.
He's not home.
Yeah, he's at work.
You know where he works?
He drives around and does like Uber and stuff, but I think I know his cell phone off the
Okay.
top of my head.
Well, they'll allow you a call when you get to the jail.
Okay.
So, you want to hang tight?
Yeah, okay, I'm on 4 if you want.
So,
Okay. I heard dogs barking in your house. What kind of dogs do you have?
They're like pit rescues.
Oh,
Yeah. One of them's getting older and it stresses me out because, I don't want him to die.
no, who does?
I know.
Because the pet, especially when you don't
Such a-
have kids, the dogs
He's such a
become your
sweet
kids.
dog too. I've had him since he was a puppy. I rescued him from the Humane Society and now Dora, I think.
Yeah, it's heavy.
yeah. We'll have to put you back in handcuffs to walk you down, and then usually the prisoner transport van, they have a belt that has handcuffs on it, so they'll move to the front.
Okay.
It'll be a little more easy for you.
That was quite the experience.
Close your eyes. You want to check?
Mhm. Is there a bathroom I could use before we were transported?
How close are they?
They're at the end of the way at the end of the
No, how close is the tree?
They were Drew Street.
This wasn't improvised. Let's examine what the law authorizes and what it doesn't. The exchanges concerning eye, color, height, and household contacts fall within the booking question exception recognized in Pennsylvania versus Muniz, decided in 1990. Pedigree questions are not calibrated to elicit incriminating information and require no fresh warnings. Substantively, the charge arises under Florida Statute 817.034. A scheme to defraud aggregating $50,000 or more is a first-degree felony, with a statutory maximum of 30 years imprisonment and a $10,000 fine. The alleged aggregate loss here exceeds that threshold more than 14 times over, placing the offense at level 7 severity under Florida's Criminal Punishment Code, a level at which a non-prison sentence requires affirmative downward departure even for a defendant with no prior record. 3 grades. The lead detective earns an A-. Miranda compliance was precise, the invocation was respected, and the demeanor remained professional. The half-step deduction reflects the post-invocation evidence summary, which created unnecessary INIS exposure. The subject earns a B+, evaluated only on conduct in the interview room, not on the underlying allegations. The invocation was unambiguous and substantive silence held. The deduction reflects continued casual conversation, which introduced marginal risk under Edwards' reinitiation doctrine. The Pinellas County Sheriff's Office earns an A. The case was built on documentary forensic evidence rather than a custodial confession, which is why the invocation did not jeopardize the prosecution. 3 lessons. First, for the suspect, invocation must be clear, unconditional, and immediate. Davis places the burden of clarity on the speaker, not the listener. Second, for law enforcement, after an invocation, the safer practice is to limit communication to procedural necessities and reserve evidence narration for the charging document. Third, serious financial crime prosecutions rarely depend on confessions, they depend on records, which is why the investigative work mattered far more than the interview ever could. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to subscribe to our channel for more content on police court interactions.